scenario. Right now, every one of my auditors knows how many clients they are auditing for the financial year 23-24. Every auditor knows they have 10 clients, they have 20 clients, they have 30 clients. And they know they're moving from this client on this day, leaving on this day, going to the next client. The lower level teams, the boots on the ground, if I could call them that, have no time to relax. The senior level teams knows that the first tranche of reviews will be about maybe 500 reports. That is within the next 3 or 4 weeks. And then from there, they come continuously. So we don't have the luxury of time to stick to the 14 days, even if it's by law. And we try to, that's where the lobbying comes in. Please, let's work together. Give me within 7 days so that the team does not have to hold back or move out of another client to come to verify what you're giving us as ML. So it has been building a relationship and communication. The DAR is good practice for just, again, building that communication and giving them one last chance. Because they'd come here and say, and I know they do, that we explained everything. But the question you should ask is, yes, you explained. Did you explain to the satisfaction of the auditor? Because some of these explanations, if you look at some of these documents you get even in truckloads, they don't explain the matter at hand. People just photocopy and attach and bring to you just to show how they have brought explanations. But if you have a document expert and you look at it, you will see it. It's not even related. Sometimes you'll find photocopies of 2020 that have no issue to do with the 2023 that you're prosecuting. And because now we are in the public hearing before the Senate, before Parliament, then my staff are also put in a bit of a difficult situation when the members tell them, can you verify, or why didn't you verify? So we need to have that agreement so that we work more efficiently and more effectively and ensure that the entities account within the timelines allowed. Indeed, by 30th of June, they should not be looking for documents. If they have proper registries, you have proper records management officers, those documents should just be pulled out and given to the auditors on arrival. So that is the issue we've been having. The committee can make a decision on how to handle additional information and how to handle the cross-cutting matters concerning the entities you are holding hearings on. I think, Chair, apart from the revenue, there was an issue on revenue.
Yes.
Honorable Chair, we now have what we call an information systems and data science team that carries out analysis of some of this data that comes in form of revenue. And you've seen probably in some of my reports that I'm now questioning the amount that the service providers are indicating as revenue raised for the entities. Because in there you have systems that we are sometimes told had some downtime. And you know that downtime revenue was still being collected. Or we have commissions that are way above what should have been deducted. And sometimes it comes out because there's underestimation of the revenue. So it's an area we are looking at with my data science team on how do we move further. Some of these service providers are a bit reluctant to share the information, but we are saying if you have been hired or recruited or procured to provide these services, then that system you're using to collect revenue should be under public scrutiny because you're collecting revenue for public services and these are public funds. So it's an area you'll be seeing in some of our reports.
Just before you, with your permission, Mr. Chairman, before you leave that thought, should you be asking Parliament to amend the PFM Act to require that all service providers, revenue collectors, okay, who collect money on behalf of county governments are 1, licensed by the Central Bank of Kenya, 2, are subject to the Auditor General audit, and then number 3, must also submit their systems to the Auditor General because it's public money. I know there are issues of intellectual property rights will come in place, but I think to be able to clean the system and to do away with this in discipline and this corruption, because that's where the corruption is. The corruption is dwelling on the revenue collectors, some of them who are not licensed by Central Bank, but they are contracted by county governments. I think there was a county in the coast which I think the percentages were almost 25% or something like that in terms of the revenue or the commission that is taken by the service provider. So that's a question. Should we be looking at that? Because I'm just trying to imagine a situation where you, so moto, decides that this is what we're going to do. Maybe it can be questioned by law. Can we then support you in Parliament specifically to ensure that there's discipline and also to ensure that at least you can be able to follow the money trail from the client to the service provider to the county revenue fund? And then also from wherever it goes. Because if we were to do a project audit, if we were to change the system audit and you do a project audit, you know, we will actually be able to reduce on corruption. But currently, we just have figures. You know, it's not line item. It's just it's not project based. It's just, just figures. They say, oh, we're going to spend 5 million on the road, but it is not. There's no narrative to say what the 5 million is all about. So I just want to engage you in that conversation to see how best we can be able to assist, put discipline there, and ensure fiduciary responsibility.
Thank you, Chair, and thank you, Senator OleKina. I would have to beg to differ. If we go that way, we will continue perpetuating an illegality. Honourable Chair, the Public Finance Management Act says that National Treasury will prescribe the systems to be in use. Now, the Public Finance Management System includes revenue collection and expenditure systems. What happened at the onset of devolution is we had a lot of briefcase suppliers of revenue systems that cropped up all over. And counties recruited them to raise their revenues or to collect for them. Then every subsequent change of administration, you will find some of these counties changing their revenue collectors for whatever purpose, without proper due diligence on whether these systems work best for them or without negotiating the terms for that collection. We have to go back to the public finance management system. We have to ask National Treasury to come in and prescribe the public finance management system for revenue collection, which should be standardized. We should not have, for example, County A paying 30% of their revenue as commissions to a certain service provider and County B paying 75% or 50%. It should be standardized, because that is where we are also losing a lot of revenue. We have different service providers from different counties charging different rates, using different systems. Some we are not even sure of their reliability, and that's why now I have my data team, my information systems and data analytics team doing some of these assessments. Let's go back to what does the law say, and how do we curb this proliferation of so-called revenue service providers and these changes that keep occurring as and when. You have some counties, for every revenue stream has a different revenue service provider. That is wastage of resources. So you can imagine, I think at one point, I think Senate requested me to give a list of all the revenue. I don't know whether it was this committee or the PAIC, and they're just too numerous. So let's go back to the basics of the law. Who should be responsible to ensure the revenue collection systems in use for collecting public resources can be relied on? Do we need to go to maybe the ICT authority to assist us here, to work with the National Treasury? Or do we need to have another authority coming in very, very strongly? That is, Honorable Chair, that is my view. Because I will be auditing as many as they are, whether they are reliable or not, and there will always be audit queries on the amounts that are being reported. Thank you.
So in a nutshell, you're agreeing with me, but you're only adding that we should go to National Treasury to prescribe the system to be used.
It's already a requirement.
You know, because it's a requirement. So we should go back to that.
It is already a requirement. By law, it's already a requirement on National Treasury. But I think that that requirement is more about operational effectiveness and efficiency, rather than it's not as practical as I think. But I think that even with that standardization, there could still be some leakages that need an audit trail. And I think that amending PFM to require an audit on those service providers doesn't take away the role of Treasury. I don't think it takes away the role of the Treasury. It just actually it helps harmonize the issue of proper financial statements that are given to us. Because in a case where counties give financial statements based on third-party indices and we don't have capacity to actually, or not even a legal framework to go and get an audit trail on those, it becomes a problem. So I think it doesn't take away from each other. I think the prescription by the National Treasury is important to the extent of efficiency and effectiveness of those systems, and compliance on that standardization. But the after use is important to audit. And therefore, we need to reinforce. I think that what Senator OleKina is proposing would actually just strengthen.
Yes, Honorable Chair, I agree to that, because when these service providers pay themselves the commissions, that is public expenditure that I should follow up and audit. And that means I go to the system to confirm how much did they collect in the first place. So if I had the backing of the law, that would really maybe unpack some of these issues.
I think just to clarify that last sentence that you said, the law does not allow service providers to deduct their commission at source. But you'll find that sometimes, because counties do not pay them when they're supposed to pay them, they deduct. So I think what we need to do is to ask ourselves what we're going to do, and this will have to go all the way to the Constitution, because the Constitution is the one which is cut and paste to the PFM Act, Section 109. So I think in terms of that, where we need to do, and we need a lot of your support and maybe your guidance on this, is how to amend the PFM Act to ensure that you go after those service providers, you audit what they collect on behalf of the public.
Yeah.
Because that's the only time that we'll be able to be sure. I can give you scenarios, hypothetical scenarios which are very real. You have a county A which has got 5 different revenue collectors, and you're right. Counties have 5 different collectors in different revenue streams. So this one collects this one collects this amount, this one collects this amount, this one collects this amount. All that money is deposited in the county revenue fund. You only audit the county revenue fund expenditures. So with that, whether these people submit the full amount they have collected or not is not something that we can be able to tell with the current situation. So I think if we look at the law, and also the fact that counties are semi-autonomous, where National Treasury deals mostly with the national issues, apart from with the role of the control of budget, allowing money to be withdrawn, we have to be very clear on, if we are going to ensure that we force these counties to ensure fiduciary responsibility, we need your expertise. I like what you said in terms of your data experts. Let's look at what your data experts are doing. Is it something that we can be able to borrow and use it in the legislation? The fact that you say the PFM Act does not allow you to begin the audit until October 1st is limiting your ability to do all that work. It's something that we take notice of, and it's something that I think this committee can initiate amendment to the PFM Act. Because really, if a county has already expended and they have staff there who are paid a lot of money, and if you look at the wage bill of most of these counties, if you look at the Treasury Department of most counties, carries the bulk of the money, then they have no excuse as to why they cannot be able to submit their financial statement on time. So I think that we need to engage more to see how we can be able to partner and ensure these issues are resolved.
Okay. Senator Vice Chair, please.